On the left, Rupert Murdoch's disgraced fake Sheikh Mazher Mahmood. On the right, British pop star Talisa Kontos-Davlos, whose life he almost ruined with false allegations and unethical and illegal techniques used to make up a fabricated story, which fortunately collapsed and meant that in 2014 the spotlight was finally drawn onto Mahmood's illegal and unethical conduct and activities, subsequently leading in 2016 to him being imprisoned for conspiracy to pervert the course of justice. However, dozens and dozens of other people have been his victim over the years of his phone hacking, drugging of drinks, fabricating evidence, and other illegal and unethical conduct, as explained at circusofthemind.net and in this video. The further documents and legal evidence and history stuff galore to back up anything stated in the rest of this video can all be found on this webpage, which is circusofthemind.net. You can see that, circusofthemind.net. Go there and you will see my grounds of appeal and in them details of the stuff that I mentioned that illustrates that the police and the CPS knew as far back as 1994 Mahmood could not and should not be considered a witness of truth. Thursday, 2nd of March 2023, as you can see, finally got a reply that says, please see the attached response to your Freedom of Information request from the Crown Prosecution Service. As the CPS state themselves in their letter, any Freedom of Information request is public and therefore this is a fully public document. It doesn't have to be private because they will publish it publicly as well. So yeah, it'll be at the link above or below this video, but just to go through it, 2nd of March 2023, you are absolutely going to find this hilarious when we get to the end, but for now, Freedom of Information Act 2000 request. Thank you for your Freedom of Information request, which we received the 9th of December 2022. The response deadline was extended under Section 10.3 of the FOI Act on 12th of January and again on the 9th of February 2023. So it's taken them a lot longer than it was supposed to have done to come to this decision. The FOI Act gives you the right to know whether we hold the information you want and to have it communicated to you, subject to any exemptions which may apply. It is a public disclosure regime, not a private regime. This means that any information disclosed under the FOI Act by definition becomes available to the wider public. Hence I can share this legally. Okay, my request. This is the request that I put in not just to the CPS but to the Ministry of Justice and various other public departments, the police and all this. We'll come to that later, but effectively what I asked was, I would like you to please search, find and supply me copies of any and all documents relating to Mazher Mahmood, the former News of the World journalist who was jailed in 2016 after the collapse of the 2014 Talisa Kontos-Davlos drugs trial, in which it was proven he lied and messed with evidence. Especially I would like you to search around 94-95 for any documents in relation to trials, cases, investigations which collapsed after Mahmood's reliability as a witness of truth was brought into question, and then supply copies to me under Freedom of Information. Further, any documents or information relating to trials, cases and investigations that have collapsed from 94 up to the present day, which relied on Mazher Mahmood as the chief witness and which collapsed fully or in part because his reliability and or truth of his evidence, etc., was brought into question in any manner, I would also like copies of all these as well. Finally, I would like you to supply copies of any and all documents relating to Mazher Mahmood's dishonesty which may have been collected in 2014, 15, 16 following the collapse of the Talisa Kontos-Davlos trial and leading to the trial and ultimate conviction of Mazher Mahmood and his then driver Alan Smith. We'll just scroll down. Finally, I would request that you fully investigate and explain to me why the police and Crown Prosecution Service failed massively in their disclosure duties to me back in 98-99 and also to all other Mazher Mahmood victims since 1994, given that the CPS and police, as illustrated by links above, both knew and communicated with each other in circa 94-95, stating then that Mahmood could not and should not be relied upon as a witness of truth in any further cases. Finally, I would also like your help in any manner you can offer to help lobby Parliament to help ensure that Part 2 of the Leveson inquiry is reinstated urgently. Their response. Get ready for this. The Crown Prosecution Service, CPS, holds case material pertaining to the publicly reported 2016 prosecution of Mr Mahmood for perverting the course of justice. Material held and collated by the CPS following the publicly reported halted trial of Talisa Kontos-Stavlos in 2014 pertains to a disclosure exercise in relation to cases in which Mr Mahmood had given evidence that led to others being convicted. That includes me, by the way. Case material in respect of Mr Mahmood's prosecution is withheld under Section 30 of the FOIA, Investigations and Proceedings Conducted by Public Authorities, and Section 40, Personal Information. The list of cases and briefing documents associated with the disclosure exercise are withheld under Section 31 of the FOIA, Law Enforcement, and Section 40. Please see the attached Section 17 notice for details of our decision. We'll look at that in a minute, because that's hilarious. The CPS released a press statement following the halted trial of Talisa Kontos-Stavlos in 2014, and this can be found in attachment FOI request reference 10991. If you are not satisfied with this response, you have the right to request an internal review by responding in writing to the address below. Well, you have the right. It'll probably be completely pointless given what you'll see in the next document, which is them explaining a little bit more about why they're not giving the stuff that's been asked for. So they've very kindly also included this Section 17 notice under the Freedom of Information Act 2000 with more details on why they're withholding information. It says Section 31C, and again, this is public info, so I'll put it at the link above or below the video, but so people can look into it themselves. But this is what it says. Information held for the purposes of criminal proceedings which the authority has power to conduct in relation to case material held within the scope of FOI request reference 10991. This is a qualified exemption, which means that the decision to disclose the requested material is subject to the public interest test. Bear in mind those three words. Those two words. I know it says public interest test, but is it in the public interest or not? The public interest factors taken into account in this case are explained below. Public interest factors for disclosure. Okay? Remember that key phrase, public interest factors for disclosure. To increase public understanding of the CPS decision-making and prosecuting process. Transparency may increase public confidence in the CPS. I believe it would. So why haven't you been transparent and released the stuff? But anyway, public interest factors against disclosure. So this is why they're saying that they wouldn't disclose stuff, which is what they've done here. They haven't done. They will not disclose if there is a strong public interest in safeguarding the prosecution process, maintaining the confidentiality of communications between the police and the CPS, as well as other public bodies, is an essential part of this process. It is important for officials to be able to freely justify and maintain their thought process when making decisions on criminal cases, without fear of the routes leading to those decisions later being disclosed into the public domain. Additionally, it is important to remember that to release case information may dissuade witnesses from assisting in future investigations. Witnesses are a vital part of the prosecution process, and it is crucial that they are able to approach the investigative body and provide statements without fear that they may one day be placed into public domain, save through the court process. Releasing this sort of information would be likely to prejudice further prosecutions. My comments on that bit? Well, firstly, it is in the public domain, many of Mahmood's cases. Numerous people who were stitched up by Mazher Mahmood and, fabricated stories and lies, and they were drugged and phone hacked and all this, that, the other. I've talked about their stuff publicly, so it wouldn't be breaching their confidentiality because they've gone public, tons of them, okay? In terms of Mahmood, well, the CPS themselves publicly stated when the Talisa trial had collapsed and that he then got charged, that he could no longer be considered a witness of truth. So, the idea that he might be a witness in the future is semi-irrelevant, really, given that they've already said he shouldn't be a witness of truth. But also, as you see on circusofthemind.net, there is evidence of the police and the CPS communicating with each other in 1994 when a case collapsed. One that's talked about in the public domain. If you go searching on circusofthemind.net, there's mention of Newcastle football directors and the case collapsing and stuff. Anyway, there's communications in 94 around the same time where the police and CPS communicate with each other and say that Mahmood cannot and should not be considered a witness of truth. So surely it's in the public, that should have been in the public interest from 1994, let alone now. But anyway, look into that yourself. We continue. There is a particularly strong public interest in not releasing information which forms part of an investigation when it has been decided not to charge. To release would be extremely unfair to the individuals involved. Well, there's a number of individuals who've gone public about the fact that the charges against them were dropped or the cases didn't make it to trial where Mahmood was the chief witness. So a number of them are already in the public domain. And those people want action taken against Mahmood for his long-term dishonesty, lies, drugging people, phone hacking, fabricating evidence, and all his other unethical and illegal activities. So frankly, I would say it was a strong public interest to release that. But hey-oh, on balance, and this is the CPS, they say, I consider the public interest favours maintaining the exemption. In other words, to not disclose stuff. Well, I'm sure many would disagree, including his victims and anyone who wants truth and clarity in the world. Section 42. Personal data relating to third parties. Some of the information you have requested contains personal data. Personal data can only be released if to do so would not contravene any of the data protection principles outlined in Data Protection Act 2018 and set out by Article 5 of the General Data Protection Regulation. Personal data shall be processed lawfully, fairly and in a transparent manner. We believe releasing requested information into the public domain will be unfair to the individuals concerned. These individuals have a clear and strong expectation that their personal data will be held in confidence and not disclosed to the public under the Freedom of Information Act. Well, already tons of Mahmood's victims have already spoken out, so they've raised their head, and I'm sure they'd be happy for stuff to be released. But aside from that, fair enough, okay. In which case, just redact their names and leave Mahmood's in. All I asked was information relating to Mahmood. You can redact other people's names, you could have done that, but it would still show Mahmood's name connected to a case that collapsed or connected to other cases and the other bits of information where he was called into question on numerous occasions, the validity of his evidence, the fact he edited tapes, blah, 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 and the various people raised the fact that they felt like the drinks had been spiked and whatnot would still be present if you redacted the names of the victims, or as the CPS may call them, the people who were accused of committing crimes. I say that in that manner because obviously the evidence now on circusofthemind.net shows that they were stitched up and fabricated in the main. Okay, next bit. Section 31, 1C, information which is not exempt information by virtue of section 30 is exempt information if its disclosure under this act would or would be likely to prejudice the administration of justice. The disclosure of internal process documents such as these could inhibit the ability of the CPS conduct proceedings fairly. This is a qualified exemption, which means that the decision to disclose a requested material is subject to the public interest test. It may assist you to understand the decision if the public interest factors taken into account in this case is explained. Public interest factors for disclosure. To increase public understanding of the CPS decision-making and prosecuting process. Public interest factors against disclosure. Okay, the CPS publishes a vast amount of legal guidance on the CPS website in order to be transparent and increase the public understanding of our practices and processes. However, some information needs to be withheld to protect the prosecuting process. The internal operational guidance is there to support those involved in the prosecution process. Disclosure to the world at large and those working for the defence would impede the work of prosecutors and reduce their effectiveness in prosecuting. It is in the public interest that CPS is confident in its ability to prosecute fairly and without prejudice to their processes. On balance, I consider the public interest favours maintaining the exemption. Do you? So hang on a minute. The fact that there's evidence exists that the police and the Crown Prosecution Service communicated with each other in 1994 saying they should not and could not rely on Mahmood as a witness of truth any further, and that numerous cases collapsed over the years with, suspicion drawn towards his conduct and what he'd done, surely that should have been disclosed to all of Mahmood's victims because they could have used that in their defence. But that was covered up and kept quiet. Even in 2014, when the Talisa Kontos-Tavlos trial collapsed, you may have disclosed a little bit of information to us victims, which you did, about the Talisa trial, but nothing major, and you certainly didn't take that opportunity to disclose to us the 1994 communications between the police and CPS saying Mahmood could not and should not be considered a witness of truth, and the other cases that have collapsed over the years, and also the number of times that Mahmood's conduct had been drawn into question. There were questions about editing tapes, fabricating evidence, people saying that they believe their drinks had been spiked, and a whole bunch of other things that are illustrated on circusofthemind.net. And yet you're saying that it's in the public interest not to release stuff that basically will back up and further prove that many of these things should never have gone to court, or that at the very least the CPS should have been disclosing stuff from 1994 onwards to victims, which it never did. What I think you mean is you need to cover up the fact that you failed massively in your disclosure obligations to Mazher Mahmood victims. And the final thing they bought is the press statement that was issued when Talisa was released. I'll put that at the link above or below this video. I'm not going to read it all out. I'll let it go past the screen so you can stop the video bit by bit and read it if you want to. But the document, as they've stated, it's all public. And at this time, in December 2014, surely the fact they'd failed up to that point to disclose the fact they knew as far back as 1994 that Mazher Mahmood could not and should not be considered a witness of truth in any further trials, and there were communications between the police and CPS stating that, which I mentioned in my grounds of appeal that you can see at circusofthemind.net, copies of which are in Newsgroup newspapers' archives for some reason. We don't know how they got them, but they come out during disclosures in the High Court phone hacking and privacy intrusion cases. So they definitely exist. And there's numerous cases that you can find by searching Google that over the years collapsed, and Mahmood's conduct and actions were brought into question that were never disclosed to us Mahmood victims, which means the CPS massively failed. And it strikes me that's the only logical reason to not disclose stuff to us, which is what they've done today. They refused to disclose anything that would basically back up everything that I state at circusofthemind.net, and we're drawing to fact these massive miscarriages of justice. I'm not going to go through all the documents, but the bottom line is I contacted the Department of Culture, Media and Sport, the Supreme Court, Manchester Police, Northumberland Police, Courts and Tribunal Services, Met Police, the CPS, Complaints Department, MPs, and basically they've all taken whatever loopholes they could to refuse disclosing stuff, because apparently it wouldn't be in the public interest. Well, I think that this massive cover-up and the miscarriages of justice would be something that's in the public interest, because it illustrates the fact that the CPS and the police further corruption, as was drawn attention to in the Daniel Morgan murder inquiry report, and they failed massively and did not disclose to victims from 1994 onwards. It's farcical. So when last year I'd got an initial CPS response saying we're not going to give you anything before I went into the Freedom of Information, and which led to what you've just seen, I made a complaint to the Crown Prosecution Service Inspectorate, and there were numerous responses back and forth, basically saying they would not get involved in an individual case. I pointed out it's not just me, it's a miscarriage of justice against dozens and dozens of people. And ultimately, on the 21st of December 2022, they said, "Dear Mr. Smith, unfortunately, we're unable to take up requests to inspect. The programme for inspection is set in advance after consultation. Our consultation period for 23-24 closed yesterday, the 20th of December. Disclosure in the CPS is not on our programme for inspection 23 or 2024. I was pointing out that the CPS should have disclosed to me and other victims from 1994 onwards the fact that in 1994 documents exist the police and CPS communicating with each other saying Mahmood cannot and should not be considered a witness of truth, and also that other cases collapsed over the years and his dishonesty was brought into question. Other things that routinely should have been disclosed to me and other victims but weren't. Basically, even though there was communications over a few weeks, they suddenly then respond here saying, consultation period for 23-24 closed yesterday. Well, why didn't you mention it first? So they could have gone through the right channels. Or is it because basically you just don't want to investigate the CPS's disclosure failures? That's what it seems like. And then if I can just get I obviously went back to them and said, please go on, actually do something. And as you can see in all those responses, they basically come back and say the same thing. They say the remit of the inspectorate is to inspect the Crown Prosecution Service and the Serious Fraud Office. I'm afraid that we do not have powers to intervene in individual cases. Well, I wasn't just mentioning me, I was mentioning the fact that dozens and dozens of people have been affected by the CPS's disclosure failures. And, well, basically, can you say, make of it what you will, but they're just sweeping it under the carpet yet again. I encourage you to go to the link above or below this video to hackinginquiry.org/above-the-law and watch the episodes that have already been released of this web series, which amongst them will include information relevant to the gross miscarriage of justice that is dozens of people who received prison sentences or other criminal penalties based upon the dishonesty, lies and illegal actions of Rupert Murdoch's disgraced fake Mazher Mahmood. And then also contact your local MP to lobby for Leveson Inquiry Part 2. There's an easy to fill in form on the Hacked Off website.